Thank you very much, boys and girls, ladies and gentlemen, for coming out on such a beautiful night and coming in here and sweltering. What you'll not be aware of is that we're going to do constitutional law in ancient Italian tonight. That's a surprise for you, isn't it? I bet you're all keen on that. Right. However, I must make a couple of preliminary remarks, and because I only have little bits of my brain left, I'm going to help myself to notes. So bear with me. I'm not making excuses, but I've had a couple of strokes, and I'm kidding myself on that I'm on the way back, despite what they say. So here we go. One thing after welcoming you is I'd like us to remember the people who 30 years ago put their neck on the line. And that's particularly Donnie and Katrina McDougall, who didn't quite understand the arrangement to meet at the restaurant. They just headed for the toll booth and refused to pay. So the first two combatants were local pensioners, but with attitude, which was good. Alex Smith deserves a mention. He was hardy, and the restaurant owner up at Dunvegan, now departed, that was Mr. Mackenzie, who was Mary Ann's husband. And it would be wrong if I forgot my partner of the 16 years, Stella Anderson, who looked after the kids while I was doing the paperwork and everything that needed to be done. And she took care of that side of the family affairs. She's now departed thanks to cancer. God bless her soul. So these folk deserve a mention, and probably some more. I might remember them by tomorrow night. We'll see how we go. Anyway, so we should maybe talk about the purpose of this meeting. I've had the brass neck to ask you all in here when you have probably better things to do. But I can announce now that after only 30 years, I have completed the legal research. And I can show that the tolling regime was totally unlawful. This has dramatic results for everyone concerned. You may not be concerned anymore, but those who didn't like getting a gratuitous criminal record, and those who had large amounts of money removed from their pockets, and especially when that applied to businesses. This is what I mean by a dramatic result, because if the toll was unlawful, all the money must be returned at compound interest of 6%. Now, they took about 150 million one way or another, so we're looking at approaching 300 million. So it's not to be sneezed at. We've got things we could be doing in the neighbourhood, from potholes to childcare to rural nursing. There's all kinds of things need sorted, and that is now our entitlement. Absolutely. I mean, I wouldn't be risking my neck. Because I'm not a qualified lawyer, I can't be wrong. I can't afford to be wrong. I have to be absolutely sure that I'm working according to statute and what I say is true and provable. So what I'm telling you is as close as to gospel as you'll get this side of Killarkin. Anyway, why bother? The main reason to me was I have an innate sense of justice. My grandfather was maternal grandfather was the county lawyer for Lanarkshire, and I was young when he died, but he had a sobering, gentle steadiness about him, despite being a Hamilton Accies supporter. He had resilience. We probably need that for Accies. And he was very careful and very considerate and very thorough. And he was the top man in Lanarkshire. He negotiated the Strathclyde, Lanarkshire divvy, who owned what, who owned all the public buildings and that kind of stuff. Anyway, that's just indicating it might be in the blood. Part of the why bother is I believe that what you accept from authorities or big people or imperialists, you will get more of. They'll keep doing what they get off with, and that's not good enough. We, as grown-ups, some of us, let's call us over 18s, we have a duty of care to our children. It's as simple as that. You can't hand your kids a whole bucket of problems. You've got to do what you can do as best you can to let them grow into as good a life as possible. So that drives me as well. Now, I've written down here self-protection from imperial overreach. Well, I think what we'd probably do here is, that's enough of a statutory law purpose, me introduction. I would like to enter into the pantomime theme now, since this is a more a theatrical venue, it has that feeling. So I'm going to suggest that instead of any negativity, any booing or hissing and troublemaking in the cheap seats, any time that you hear something you don't like, you use the expression, a wee village in Czechia, right? A wee village in Czechia. Now, could I just hear that from everybody? A wee village in Czechia. Perfect, a wee village in Czechia. That's going to purge your anger, your bitterness, your resentment, and instead of, we just say, a wee village in Czechia. It's a secret, but it works. I've written here in large print, Fiat Justitia. This is the beginning of your constitutional law lessons in ancient Italian that I promised you earlier. And it's very brave of you all, because not many of you will be familiar with ancient Italian anymore. They called it, it was the Romans that brought it. They called it Latin, but that was a wee corner of Rome. It's basically ancient Italian. So that's the title of this, and I'm going to break it into parts and see how you go eventually with the ancient Italian. There's a constitutional history in Scotland, and I have to draw your attention to that. Road tolling had been banned in Scotland since 1878. And that was a result, the reference there is the Roads and Bridges Scotland Act, Section 33. This national ban, which was in place until repealed by the Roads Scotland Act 1984, 7 years prior to the passing of the new Roads and Streetworks Act, are you confused yet? By the Parliament at Westminster in England. So we lost our national ban in 84, it was repealed. And then 7 years later, we had the arrival of an act from London. So this United Kingdom presumed to reintroduce road tolling to the elder kingdom while bypassing the authority of the Scottish Parliament. There was no consultation with our Parliament. We're a popular sovereignty. The people are sovereign. If you're going to fundamentally tackle and rewrite laws, then the people should know about it. It should be a public decision. So, what happened here was very confusing. The introduction of the New Roads and Streetworks Act, 1991, I don't know what we should call that for short, the 91 Act, right? It created an unprecedented international hybrid of required legislation. And attention must be drawn to the importance of the following first three items. We can distill all of this down to three pieces of legislation you'll be pleased to hear. Now, no lawful toll regime can exist and no monies can be lawfully demanded, any such demand being potentially criminal, if you don't have these three documents present and in proper order. I'll take you through them as smartly as I can. One is called a special road scheme. Under Scottish legislative requirements, and that's contained in Section 7 of the Roads Scotland Act. How you get on so far? Secondly, a toll order. You have to combine, you have to make a tripod here to support tolls. The second leg is a toll order. But since we didn't have tolls in Scotland, they were banished back in 1878, Section 33. You'll be sitting an O level on this before you're allowed to leave the building, of course. Anyway, a toll order is under Section 27 of the United Kingdom 91 Act, New Roads and Streetworks Act. And basically that act is designed to support PFI. It's a backup for PFI, which is an English idea whereby private hands get in the public purse, and rake about. It shouldn't be. The third object that you need, and I promise I'll stop talking legislation after this, is called an assignation statement. And what that does is identifies, as you would expect, the authorised toll collector. The good thing about the assignation statement from our point of view is it's governed by regulations in Scotland. There is a requirement for prescribed information. Prescribed is prescribed by the Secretary of State. He must take responsibility for producing that licence. I've yet to see it. This was required under formal regulation, and I can quote the number for anybody who wants to go home and work on this later at night. It's an SI, statutory instrument, dated in 1991, and its number is 2152, S for Scotland, 177. So they've written a law which controls the license, the nature of the license. You must do it this way for it to be in lawful order. So just to rehearse that, you need a special road scheme, which is a platform for doing something strange on. I mean, there's a special road scheme out there to control the 40-mile-an-hour limit. That's an example of a special road scheme. The special road schemes going past Baillieston in Glasgow, I've got a list of 10 of them probably, when they were upgrading the motorway, they were planning to build the motorway, which became the M8 between Glasgow and Edinburgh. So that had to be based on a special road scheme. The other requirements don't need to concern us. Now, I'm satisfied now, after considerable searching, that none of the above requirements were met in lawful or proper form. Absolutely no attempt to produce either the assignation statement, or there was a thing called an alternative route certificate. You can't channel people into tolls without giving them an option to go roundabout. They couldn't issue an alternative route certificate. I chinned Lord James Douglas Hamilton, and he told me, of course there's an alternative route. You go to Inverness, and then you go up to Ullapool, and you go on a ferry. You know, what's your problem? You're a real country boy, aren't you? Right, so then I discovered that they had produced poor imitations of the required documents, so I got hold of them, and they had to be signed by the Secretary of State. If you produce legislation that gives orders, makes regulations, controls people, it has to be done by a cabinet minister. And we only have one cabinet minister, and that's the Secretary of State for Scotland. No one else is allowed to write law in Scotland, only that one guy. At that time, it was Ian Lang. So I checked, and neither the Special Road Scheme nor the toll order was signed or even rubber stamped on behalf of the Secretary of State for Scotland. And the seal of state, which must be applied to show that it's Lang and its legislation, you know, be humbled, beware, that was completely absent. There was no attempt. So effectively, the legislation hamper is completely empty, falling in every single regard to comply with statute as it then applied to Scotland. Nonetheless, the arrival of the New Roads and Streetworks Act introduced two criminal offences for what might be considered more a civil or a minor matter. They were going to enforce the application of road tolls. This was the Tory thugs, you know, introducing PFI. So they made this law, Section 38(1), refusing or failing to pay a toll without a reasonable excuse. That's the one we suffered under if we objected. We said, we have a reasonable excuse. You don't have a tolling licence. Your paperwork isn't in order. And this went right over their heads. Are you paying or are you not paying? Well, I've told you that the answer to that is conditional. If you can produce proper paperwork, I'm happy to pay to avoid the hassle. It's a bit expensive, but if it gets me to Inverness and for the moment, then I'll pay if it's legal. And that's a perfectly reasonable position. But there's another part in the section before, section 37.4 of the same Act. And it said, demanding a toll without authority is also a criminal offence. So I thought, I like that one. Let's have a look at their authority. I've never found it. In 30 years of searching, I cannot find any substantial or even insubstantial authority. It doesn't exist. However, we can address this because let's take the most deadly flaw. That's their disrespect for the special road scheme. Unlike in England, that item of subordinate legislation had to be produced according to Scots law, as contained in Section 7 of the Scotland Act 1984. That's another one for you to remember, Section 7 of the Scotland Act 1984. How are we doing with constitutional law so far? Nobody's fallen asleep, nobody died? Okay, that's fine. I'll risk continuing. Now, Section 7 says, and this is where I basically felt confident. I wasn't arguing with sheriffs that, oh, I'm not paying, you should be letting me through. I wasn't having any moral argument with them at all. I would just say, my Lord Sheriff, Section 7 of the Road Scotland Act 1984 says, a scheme under this section authorising the provision of a special road shall, in the case of a road to be provided by the Secretary of State, be made by the Secretary of State. He has to create that scheme. That scheme is a form of subordinate legislation. It's proper legal paperwork that has to be raised. You can't ignore it. It's the law of the land. And then it said, over in the New Roads and Streetworks Act, the Tory PFI Enabling Act, at section 27.4 and 5, for anybody who's deep into this by now, the proceedings 4 says the proceedings required by Part 2, I should say this in an English accent, shouldn't I? Well, the proceedings required by Part 2 of Schedule 1 of that Act to be taken for the purposes of a toll order shall be, as far as practicable, be taken concurrently with the proceedings required to be taken for the special road scheme. Got that, sunshine? The Secretary of State shall not make or confirm the scheme or the toll order unless he makes or confirms them both. They've both got to be done together. Right. Their problem then was special road scheme was made under Section 7, and that was done a certain way, and it had to be done by the Secretary of State, as we said before. He is the only authority. But they were allowing, I've forgotten the word, toll orders. They were allowing toll orders to be made under English law, the New Roads and Streetworks Act. Now, that was a hybrid that was doomed to disaster because the people who were running this were running it from London, and they were bulldozing, the civil servants or whoever was dealing with it in Edinburgh. They were just getting trundled because Thatcher had this brainwave. Thatcher and Major were away with themselves. Oh, let's privatise roads, let's privatise bridges, look at the money you could make. It's a godsend, it's brilliant. So they've then got a problem. If you've got no product when it comes to the special road scheme, and you've got to tie that up with a toll order, even their English law says if they don't match happily, they can't happen. They have to work together. They have to both be in order to set up a toll regime. So neither of them was in lawful order. Now, this is back to why. It's down to the Secretary of State had to be responsible for signing the special road scheme in Scotland. He had nothing to do with the toll order. That was done in London. But they both must be signed by a minister. And a toll order in Scotland needs a signature as well. They both must bear the seal of the Secretary of State for Scotland. This hasn't happened. This just didn't happen. They didn't respect the requirements of the special road scheme. And the paperwork I found was, I would call it a draft supplementary. At best, it was worthless. It lacked the statutory identity number for the year of issue and was signed by a deputy roads engineer. A deputy roads engineer signed the toll order that took all your money in Scotland. A deputy roads engineer signed the special road scheme. Are you having a laugh, sunshine? However, to the public's dismay, the Sheriff at Dingwall accepted this legislation as having full merit in law and proceeded to employ this paperwork to convict members of the public who had highlighted the shortcomings and these other failings as their reasonable excuse. They were turning around and saying, "Where's your paperwork? This is not good enough." Now, to the eternal credit, some Scots in this neighbourhood and some visitors and friends had the backbone to join in a protest and say, this is not right. You're taking liberties here. And the Scat community burgeoned. I asked for 100 at first, based on the Declaration of Arbroath. So long as 100 of us remain alive and with sufficient grumpiness, we'll be remaining independent, thank you. And I thought that was a good marker to put down a minimum. As long as there's 100 of us alive, you can take your steam road rollers and hike back south. So, what happened in the High Court of Appeal? Because Jimmy Fraser in Dingwall just went guilty, guilty, guilty. He was not listening to evidence, not listening to explanations, not listening to any excuse, reasonable or otherwise. He just rubber-stamped guilt on everybody's forehead. And that has its problems. So in Edinburgh, we steered ourselves down there appealing against this outrage. But people fared no better. Lord Sutherland became the lead demon. He was packing his bags for Camp Zeist and a high-profile Lockerbie trial. But somehow, in that 3 weeks, he released an opinion demonstrating, in my view, cataclysmic ignorance of Scottish roads law. He didn't know about the special road scheme under Section 7. He didn't have a clue. You know, he just tried, grumble, grumble, mutter, mutter. And he came out with an appalling opinion. I had it checked, I'll tell you about that in a second, by a forensic writing analyst. I was very suspicious because I've read a few legal opinions and I didn't like the look of this. And this writing analyst immediately separated the styles of 3 persons contributing to allow his view to be made public. I've misphrased that. The analyst was not willing to allow his view to be made public. He broke it down and said to me, I can only tell you this on a private basis because I'll never work again. You know, I work for the courts all the time saying, you know, what I think about origins of writings. And if I told you, if the truth got out about what I'm telling you now, I would lose my work. That's the way they would treat me. So I understood that. So we're back to Lord Sutherland. He's allowed to get off with some very interesting comments, which I'll come to in a minute. Lord Sutherland's opinion supported an emphasis on a mere part of a Latin maxim. This is when we get back to ancient Italian for a wee minute, so bear with me. He said, our Lord Monarch sitting beside him wrote up, Omnia rite et solemniter acta praesumuntur. And we were all meant to go, aye, all right, big man. We're just peasants. You just blast out that old Italian and we'll just salute and go home and take it in the rear. You're joking. You know, I have an O-level in Latin. It's not much, but it's helpful. And I was able to check out this omnia rite and what it meant. So on the face of it, straight away, it translates as all acts must be presumed to have been completed in proper order. So that's what he's shouting at me. All acts are presumed to have been completed in proper order. But that's only half of that maxim. The latter half of the maxim, he crucially omitted. The latter half, which is back to us coming and doing ancient Italian and constitutional law on a Tuesday night, runs donec probitur in contrarium. That has a very significant meaning. That translates as unless the contrary is proved. So you have to allow them to get off with what appears to be good, unless you can prove, the burden of proof is on you, the contrary, that's not true. The paperwork is not in proper order. The presumption of perfectness is burst, gone. So I thought, well, that's a bit nippy, you know, closing ranks here, that's actually a form of corruption. So I appealed this, and once you've been heard by the likes of Lord Sutherland, that's the Supreme Court, and they think, right, let's put him to bed, you know, shove a little Latin up him and get on your bike, sunshine. Don't come back here with your cheek. You're a peasant, pay up. You know. And I wasn't happy with that. So I found a device called a petition to the King's Noble Office. You can't do it in England, but you can do it in Scotland. And this is back to the old days when Scotland respected Scots, respected law, and England just did what it liked or what it could get off with. But we were more principled. You know, we stuck to our guns. The law of the land was significant, was important. So we had this device called a petition to the noble office of the king. I ran that as far as I could, and I got straight from Lord Sutherland to the Lord Justice General, Lord Cullen. I thought, wow, they're taking this seriously. And Lord Cullen turned out to be equally ignorant of Scottish road law. He didn't have a clue. And his attitude was quite interesting. He blocked it on the grounds of competence. You know, he just brought down a meta-hammer, a rule. You can't have the interference of the people you're complaining about to the king ruling over your access to the king, or, you know, this petition procedure. And he was, Cullen, top man, Lord Justice General, just said, you can't have this hearing, you can't have this appeal, you can't have this discussion. Now, I found out that Cullen was a member of a secret sodality, and 4 other members involved in this game were also members of a secret sodality, the same one, called the Speculative Society of Edinburgh. There you are, I've named you. Kill me. The judges who sat on either side of Sutherland were members. Sutherland himself was a senior Mason, and Cullen was a member. So they're closing ranks and backing each other. I don't want to tire you with the shortcomings of our judges, but I'll mention one more. And I took this into the civil arena because you should have rights under law not to be wrongly convicted. A criminal offence and conviction is important in your life. So I thought I'll leave that alone and try and go into the civil half of Edinburgh. But I landed up against Lord Eassie, Eassie, and he chose to absolutely ignore the requirements of the assignation statement regulations. They didn't exist as far as he was concerned. He ruled that it was none of my business. I couldn't base a complaint about the assignation statement not being obeyed. They hadn't complied with the requirements, my lord. I couldn't talk about that. It was declared by Eassie as none of my business. That's an astonishing rule. But you have to keep your sense of humour. So it's none of the public's business if the members of the speculative society want to make money. That's what it boiled down to. They were setting up a toll regime. The local fellows, Sir Ian Noble and a banker, Lord James Douglas Hamilton, the Minister of Transport in Scotland, he was a member, and it was all looking very cosy. So was a senior civil servant who was organising the paperwork surrounding, the deals. He was a member of the speculative society. So I thought that was rather unhealthy. And I wondered, how Lord Eassie might have responded at a toll booth on being asked for £20 to permit his camper van to pass by an anonymous person with no tolling licence. Would you be happy with that, Lord Eassie? Just give me 20 quid, Lord Eassie. Why? Where's your paperwork? I don't have any, and if you don't give me 20 quid, I'll call the police and have you charged and arrested. I don't think anybody's going to enjoy that. Anyway, there was one more comment I had to make about Lords before I move on from that. The Lord Justice General, Lord Carloway, he's grossly embarrassed himself. He's now retired. He's had the decency to retire. So what I did, being an activist, I invited a speeding charge on the M74, because if you want to do anything different with a road, you have to have a special road scheme, as a basis for building something else on top. So I calculated the speed, and I knew that Procurator Fiscal would allow 10%, so you could do 77, and then they would probably allow another 3 miles an hour, probably be 80 before they processed you. And that way the money's coming in and there's no argument. You were doing 80 miles an hour. Oh, we can prove it. We've got guns. So Carloway heard my appeal on being convicted for speeding on the M74, and he absolutely condemned the fact that someone was challenging this. He just issued an ad hominem, back to more ancient Italian, against the man, not reading the statute, an ad hominem attack on me. And I felt like Muhammad Ali and George Foreman. And Muhammad Ali said after round 4, "Is that your worst shot?" He got up off his knees. "Oh, you're in trouble, George." That was a parallel I saw. Now, curiously, Lord Carloway's judgment against me, which is PF Dumfries versus Robbie the Pict, or the other way around. It's been removed from the official website. You know, my argument was in there saying you can't set up a speed limit if you don't have a special road scheme, and there's no sign of a special road scheme. That whole M74 is made up of blocks that are supposed to be an accumulation of special road schemes, and then they zip it all together and make it a motorway. But you need the special road schemes down first. They didn't have it. So there's no speed limit. It was a good test case for me. But, quick closing of ranks and slag off the Pict, you know, so there we go. All right, we're closing up. So the question remains, what went wrong with the PFI experiment in Scotland? How did the dream of Thatcher and Major dash itself on the rocks in such a spectacular manner on the Isle of Skye? We've put a spanner in their works, big style. Now, the answer to that lies back in Edinburgh. A civil servant by the name of Fiona Drummond was permanently attached to Secretary of State Ian Lang's section of the Scottish office with a chap called David Nash. Such a person was responsible for ensuring that any legal acts to be performed by the minister were carried out according to the law. Lang's not expected to know anything about the law. He's busy buying and selling property in America. So here. And it's up to the personal parliamentary information advisor, the person who's meant to be keeping them right, to draw attention to the requirements surrounding the erection, especially of something like a Skye crossing. Miss Drummond failed to recognise that Scots law made different demands on the creation of the special road schemes than the law of England, something we all know in this room already. Section 7, Road Scotland Act, makes demands that the Secretary of State must sign, and if he isn't present, his Undersecretary can sign on his behalf, but state that that's what he's doing, signing on behalf. And there must be the Secretary of State's seal, and that hadn't happened. It was clear that Lady Drummond, as she now is, didn't know that. Now, that may be a wee shock to you. I've just said Lady Drummond. Well, Lady Drummond was that same Fiona Drummond who was working for the Solicitor General at that time, and that was after Lang. And it was her responsibility to protect the Scottish public by checking the legislation and drawing attention to it. Now, I think she's dropped the ball in a big way. And I would say that she's responsible. She's the root problem, not doing her job. Lady Fiona Allison, with 2 L's, Drummond. For those who want to write her a wee note. Now, Miss Drummond has nonetheless enjoyed rapid promotion. As I said, she's now Lady Drummond, and she's a High Court judge. She was fired up the ranks in, as a junior counsel. Then I think she was a QC for maybe 11 years. Some people are QCs for 30 years and don't get made judges. So I would say then to, should I call her Lady Drummond? Well, probably, wee Fiona. I think you've dropped the ball. I think you've made a mistake. Now, you were young and you were probably bullied by the monster Thatcher, and the instructions were sent down with London-style authority, and we know they're good at that. So I would like to ask you, on behalf of the 130 souls wrongfully convicted, to re-examine your role in this sorry affair. And I'm putting it on you, and I'm suggesting the public right to her as well. Do the decent thing. Demand a public inquiry after an interim payment. You're wrong, and clearly wrong. I would like to see an interim payment of £20,000 to everyone who was prosecuted, and of £50,000 to the 130 people who were convicted, for each and every conviction. There's a whole lot more money getting handed out in compensation, you know, for skullduggery in Glasgow concerning football clubs and all kinds of stuff, North Sea, whatever's going on. So unless you can say you didn't work for Lang, and unless you can point the finger at someone else as being responsible, wee Fee, you are in the frame. You need to explain yourself. And I'm being blunt about it, because it's been a blunt instrument up here. It's affected a lot of our community and businesses, you know, transport, tourism, all that kind of stuff, in a very bad way. And reparation must be made. And I think I'm in a position to show how it can be properly demanded. So that's my position. I've got all the paperwork to prove everything that I've said. And I'll tell you one wee thing that's amusing. When I went in front of Lord Easy and took the civil charge, there was a list of authorities supplied to me by the Secretary of State, who was the second respondent to me. And the Secretary of State issued a copy of the notice of a proposal to make the Invergary-Kylovalchalsh trunk road extension toll order. Now, that identifies in the official paperwork reproduced by Sweet and Maxwell. It's what they all use, and it lays out that this is a trunk road extension. Now, when they issued the first special road schemes and toll order, they denied that it was anything to do with the trunk road. They said it was a local and private non-print. It didn't need to be scrutinised by Parliament. Now, a local and private non-print is like, I would say, similar to a church path. It doesn't govern or prohibit anything. It doesn't do anything. It just says it's a road that exists and it's allowed to exist. And that's what they used to avoid scrutiny, local and private non-prints. But here they are saying this is all about the A87 extension. and they call it Trunk Road Extension. So that's the Secretary of State's documents that they used against me. And I thought, you are really stupid. I'm going to keep that as a souvenir, which is I've done. You know, thank you very much. They could afford to print it out and put it in nice folders. I'm finished. I've got a list of, I'll not bore you with this, but there's special road schemes around Glasgow in the 70s. Motorways, ring roads, Monklands, Hings Ingleson, Baillieston Interchange. All of these special road schemes were published. They've all got proper names, statutory references. They're all in legitimate forum. So what happened to the Skye one? Why was that not in legitimate forum? So I'm very much obliged for you patiently listening. That's all I've got to say on that, but that's nuclear. I can back that up anywhere, and I'm willing, I want to retire now. I've done 30 years in July. June 20th, that's when I first came to the island. I was only visiting. And I went, this is outrageous. What do you mean? You know, £5 for my car. I don't want to camp. It was ridiculous. And I had a look around, and there was nobody else really in a position legally to take up the cudgels. I'd been a pest in the past. You know, I'd been refusing to pay English road tax for 10 years by then. I was running about in my own, with my own registration plates. You know, I was officially a qualified hooligan constitutionally. So I could see, well, you know, I seem to have walked into a line of fate here. This looks like it's going to land on my lap. And I didn't fight it. I could see that the other folk had other interests. You know, in the neighbourhood, the one lawyer was interested in conveyancing property and rubber stamping the applications for legal aid so he could get 50 quid from everybody that went up there. He did occasionally respond to some things, but it wasn't his gig. You know, that wasn't his interest. I had already, you know, considerable experience. I'd done maybe 20 high courts by that time. I was in the middle of suing the Queen for the return of the stone of Scone. Lockerbie hadn't happened, but I was helping out with that eventually. But the job kind of landed on my lap, let's put it that way. And I thought, well, you've been mouthing off about fighting for Scottish rights. Here's your chance, big man. Okay. Guess it's down to me. So I've done the best I could. I want to quit now because my 30 years will be up in June. I like to play tunes, as Shifty knows, and I'd rather go back to playing the harmonica and relearn how to play a slide guitar and stuff like that. But I'm willing to help any young Turks, if there's any undergraduate law students that have a sympathy for Skye or Scotland, I will go through my collection of paperwork, and I do have a collection of paperwork. I've exhausted them. I've annoyed them. I even annoyed Charles Kennedy. Stop. I said, well, do your job. So at this point, I'll shut up. And I didn't get Round of applause for that.
My name's Paul. I live in Broadford. You were mentioning wee fee and saying that lady, the onus is on her at the time to have protected people from this imposition, because she should have known the law and that could have stopped it. And as an idea, people contacting her, is there a form letter or something you've got with bullet points that people can use to put together a letter themselves to write to that lady?
I can arrange to post some bullet points, and people can take them up as they feel. Oh, I can relate to that. You know, where is the tolling license? You know, why wasn't that in proper order, or whatever your question might be. I will undertake to answer anything that's sent to me as best I can. I realise you can't retire and just drop a guillotine, you know, because I'm probably the only person who knows everything about the regime. So dream up any questions you want, based on anything you've heard tonight or might appear in the papers. You're very welcome.
Mike Lights from Broadford. Are the people who are convicted, are the people who are convicted, and have they still got a criminal conviction against their names, and would they be an obvious sort of basis of people to take this claim forward that you were talking about for compensation?
Anyone who has a conviction is entitled to cast it up. Convictions don't fade away in Scotland. In England, they tell you, your 20 years are up, too bad, it's died on you, suffer it. But a wrongful conviction in Scots law lasts forever, and you're entitled to challenge it forever. So some of that will come about. I'm going to do a group approach, and that's why I'm addressing Lady Drummond and say, you've had a hand in this, why don't you sort out all of these, give a judicial review of what's happened, conduct a judicial review yourself, purge your guilt, because you've let everybody down. And I don't think you're a bad person. You're a young woman, you know, with a career in front of you, but you shouldn't be hiding behind privilege in a matter as radical as this. There's tens of millions of pounds involved. There's wrongful criminal convictions that have hindered people, not in a big way, but I've had examples quoted to me of folk turning up at the airport in New York and not being allowed in the country, turned at the gate because they had a criminal conviction. And they thought, oh, just a toll order. Americans didn't see it that way. It's a criminal conviction. No go. So these kind of things have to be eliminated. They're not a big problem, the criminal convictions, but the money's interesting. You know, we're talking tens of millions of pounds. I mean, a ballpark figure for me would be $250 million. I think it would amount to 250 million at least. That's what's due back into this community. That fills a few potholes. That staffs a few homes for the aged, hospitals, the stuff that we need. It allows us to fight wind farms and so on. We could be well equipped. We could all have printers. So it's worth doing, and it remains an open sore, and we are entitled to pursue it.
Hi, Robbie. So I'm hearing similarities between the recent post office scandal that took place here in the United Kingdom, and I'm wondering, do you think that we should have some kind of dramatisation of the events in order to reach people, given where we are in society in general and how people look at the television and how they look at media? Do you think that making a programme about it, you know, with a dramatisation might be a way of reaching people? Obviously, they already made the documentary for BBC, The Battle for the Bridge, which you were actively part of. But do you think that actually having it as a programme might be a more effective way of reaching people, so that they would then want to pursue it and go further to taking it to Wi-Fi and other people like that?
I think that's a great idea. I've no objection to that, and would contribute where I could. We're up for any development, any expansion. Scotland should know about this. Scotland should be angry. It's not just a local problem. We've kept it local because unless you've got them, they'll slap you down. And there's a famous phrase in Westminster: I refer the gentleman to the answer I just gave. Pardon? You know, that's it. That's their standard patter. We don't want to talk about this anymore. We should be exploring every possible idea to keep this at the forefront in Scotland, one way or another. I've got some ideas which I will not be disclosing, but they're fun things. I've done my shift on the head down legal stuff. I've got them. I'd like to go out and be a nuisance again in a kind of a happy way.
Just on the same thing as you were saying there yourself about like drama, has it been put in print? Because it would make a really good book, and it's easy to print now, and also and to distribute. It's cheap to do, but you can also reach a really wide audience through it. So that's another way of disseminating the information.
We've got to keep fighting. We're protecting our children. What you accept, you'll get more of. You know, if you lie down, you'll stay down. You know, there's things to be done. You have responsibilities. Thank you very much. Good night. God bless. And let's all pray for each other. Praying's not a bad thing. You know?